South Africa has just concluded its first transfer pricing court case. Experts say more cases expected to surface as SARS increases efforts to clamp down on aggressive corporate tax structuring. Director at Graphene Economics, Michael Hewson, joins us now to unpack this. First of all, Michael, just what is transfer pricing and why is this case important?
Good evening, Matteo. Transfer pricing involves the price set between multinational entities and for transactions from one entity to another entity involving goods or services, intellectual property, or basically any transfer of value, normally from one country to another, but sometimes within the confines of a particular country. Transfer pricing is particularly important because it's estimated that approximately 60 to 70% of global trade takes place within multinational enterprises. So it's really important from a multinational perspective, as well as from a revenue authority perspective, to ensure that prices are set at market-related prices.
What came out from the case that could affect South African companies and multinationals in terms of transfer pricing?
The first thing to note is that this is actually the first transfer pricing case that has gone to court in South Africa. Transfer pricing regulations have been in South Africa since about 1995, but it's the first matter to actually go to case. And it's expected that there will be a number of other cases going to court in the near future. What particularly stood out in this particular case is there were provisions that had been focused on by the taxpayer to support its position, but there was a very particular set of facts in the loan agreements and the arrangement entered into that the court looked at and really focused on in deciding the matter. So what's really important to taxpayers in this particular case is to ensure that you very carefully consider all the relevant features of any cross-border related party transaction and any supporting documentation to ensure that there's consistency in the position taken.
How do companies stay within the law in terms of the revenue collector? And I know there's a lot of interest from SARS in terms of this transfer pricing. What exactly are they looking for from companies?
What SARS is looking for is to ensure that the prices charged and the profits earned for transactions taking place cross-border is fair and market-related. So it's important that the profits earned are appropriate in relation to the value added in a particular country. So the question is always, how do you demonstrate value? If you render a service, how do you show that a service is worth a particular amount? And sometimes there's a little bit of subjectivity in it. One company might value a service in a certain way, another company might value it slightly differently. So there's a number of different factors that need to be taken into account when establishing and determining a market-related price. You've got to look at the contributions of the various different parties. You've got to look at industry-related factors. So, for example, a service to a particular industry might be more valuable than a similar service to a different industry. You've got to understand the country-specific factors. So, for example, in Africa in particular, moving goods around the continent can be quite challenging in certain countries. That's a particular factor that you've got to take into account.
And in terms of getting in trouble for transfer pricing in terms of SARS and the regulators, would it be a matter of understating the value and quoting the wrong transfer price?
Yes, it invariably would be. Sometimes the price would be understated. If you're importing goods or services, it might be overstated, with the result that your profit earned in South Africa is less than it should be.
We're seeing the continent trying to move into intra-Africa trade, and I know you were talking about multinationals and how those different levels will be affected by transfer pricing. In terms of just trading within the continent and not anywhere else, how does transfer pricing play a role there?
Well, I see it as a very positive development that now 38 countries in Africa have got specific transfer pricing legislation in place. And it's interesting that 28 of these countries have implemented their rules since 2011. And there's been a lot of focus on implementing legislation. I see that as a positive because it brings with it increased certainty for business, and the added certainty for doing business in countries enables better and more informed decision-making for business. So there certainly is a lot of focus on implementing and introducing legislation. What needs to come then is also increasing capacity in order to enforce transfer pricing and ensure that there's consistent interpretation regarding the legislation by taxpayers and tax authorities.
And just quickly, how do African countries pick a currency? Because internationally it's the dollar. What's the fair pricing for us?
Well, that's an interesting question. There's not particularly specifically an appropriate currency. Companies typically try to engage in currencies that will minimize their foreign exchange risk, but it's not as if there's a particular currency they should be transacting in or operating in. It's the one that makes the most commercial sense to them.